Well, gentlemen, you know it well. When society came into being, three systems emerged automatically. One is known as economic system, second is known as political system, and third is known as moral system. In our systems, if we go deep into it, we find that it explicitly reveals that there were three types of relations amidst its members. One type is which relates to the relation between man and man, and relation between man and group, and a relation between group and group, or class and class. So these relationships are regulated by the social contract or by the statutory provisions as promulgated by the person in authority. So when we talk of the relations between these classes, we find that they have rights and obligations. There are certain rights and there are certain obligations. One party has a right, the other has the corresponding duty. And one party has a duty, the other party has the corresponding right. So these rights are regulated. Same is the case with the relationship of a landlord and tenant. A tenant has certain rights, at the same time the landlord has also the rights. So in order to regulate these rights, civil courts has the jurisdiction to try all suits of civil nature, unless their cognizance is expressly and impliedly barred. So originally, the civil court has a jurisdiction to regulate the relationship between the landlord and tenant. But it created certain problems. So the state was of the view that these relations should be regulated by an independent statute. So West Pakistan Urban Rent Restriction Ordinance came into being. In that ordinance, there were the clauses which proved the regulations between the landlord and the tenant. But with the passage of time, it was realized that a landlord cannot bear the brunt of protracted litigation. He has to suffer a lot. The tenant had more rights than those of the landlord. When the tenant had the rights, the law tilted in his favor, and the landlord had to face certain odds. The tenant was having various types of defenses, and one by one he used the defenses and never allowed the landlord to enter into the premises. So this reality was creating an odd, and it was thought that some rights should be given to the landlord as well. And there should be a balance between the rights of the tenant and the rights of the landlord. So keeping in view the Urban Rent Restriction Ordinance 1959 was repealed, and a new ordinance in 207 came into being. And that same was also repealed by the Punjab Rented Premises Act 2009. Section 36 of this ordinance says repeal and validation of this law. The Punjab Rented Premises Ordinance 2007 was repealed by that section. But this section has some validation of certain acts and the proceedings. And it reads, notwithstanding anything contained any law, anything done, proceedings or action taken, order or rule made, liability incurred, a right acquired under the Ordinance 21 of 2007 are purported to have been done, taken, made, incurred or acquired under that ordinance from the date of promulgation of the ordinance till the coming into force of this Act shall be deemed to have been done, taken, made, incurred, or acquired under this Act. So this was a validation clause and a repealing clause. It validated certain proceedings and it repealed the Ordinance of 2007. Now the Punjab Rented Premises Act 2009 came into force on 17th of November 2009. The preamble of this ordinance, of this act, explicitly reveals the intention of the legislature. So it speaks, whereas it is expedient to regulate the relationship of landlord and tenant, to provide a mechanism for settlement of their disputes in an expeditious and cost-effective manner, and for connected matters, it is hereby enacted as follows. So this act was enacted for the purpose of providing a mechanism and for the purpose of regulating the relationship of landlord and tenant. So this act came into force. The object of this act was to create a balance between the rights of a landlord and the rights of a tenant. And the earlier act was repealed on this reason that that was providing more defenses to the tenant. So the objective of this act is, that there should be no unscrupulous or vague type of defenses for the tenant, and the tenant should not get undue advantage of his position. So this act came into being. Now, the Punjab Rented Premises Act 2009 came into force for the purpose of regulating the relationship between the landlord and tenant. There is a difference between Urban Rent Restriction Ordinance and this act. The main difference is that the Urban Rent Restriction Ordinance regulated only the relationship within the urban areas, while this act was enforced for the whole of the Punjab. Section 1, subsection 2 says that it shall extend to the whole of the Punjab, meaning thereby that the condition of urban property was removed therefrom. Now we are going to study it para-wise and with section-wise. सेक्शन 2 में इसकी डेफिनीशंस दी गई हैं. सबसे अहम डेफिनीशन इसकी है बिल्डिंग. सेक्शन 2 की पहली दफ़ा ए में बिल्डिंग को डिफाइन किया गया है. इस दफ़ा के 2 हिस्से हैं. We are to keep it in mind that the building in this section means only for the purposes of this act. इस एक्ट के लिए बिल्डिंग को उन्होंने डिफाइन करते हुए ये कह दिया कि कोई बिल्डिंग या किसी बिल्डिंग का कोई हिस्सा और उस बिल्डिंग के तमाम टुगेदर विद ऑल फिक्सचर्स और वो तमाम चीज़ें जो इस बिल्डिंग से वाबस्ता और पैवस्ता हैं, वो तमाम चीज़ें बिल्डिंग में शामिल होंगी. और इसमें गैराज शामिल है, गार्डन शामिल है, गोडाउन शामिल है, आउट हाउस शामिल है, ओपन स्पेस अटैच्ड और अपार्टमेंट्स अपार्टिनेट शामिल हैं. लेकिन इसमें कुछ चीज़ें ऐसी हैं जो शामिल नहीं हैं. वो हैं, it does not include a room in an hotel, hostel, boarding house, गेस्ट हाउस और एनी प्लेस ऑफ रिलीजियस वर्शिप. यानी जब हम बिल्डिंग की डेफिनीशन को पढ़ते हैं इस पंजाब रेंटेड प्रेमिसेस एक्ट 2009 के तहत, तो हम इसको 2 हिस्सों में बांट देते हैं. एक वो चीज़ें हैं जो बिल्डिंग हैं और दूसरी वो चीज़ें हैं जो बिल्डिंग नहीं हैं. अब इस बिल्डिंग की डेफिनीशन को हमने एफ क्लास जो प्रेमिसेस की डेफिनीशन है उसके साथ मिला के पढ़ना है. Premises means a building or rented land not being an agricultural land or land subservient to agriculture. اب premises کے معنی انہوں نے کر لیے کہ بلڈنگ یا رینٹڈ لینڈ. بلڈنگ کون سی؟ جو بلڈنگ کلاس اے میں دی گئی ہے. جب ہم بلڈنگ کے معنی پڑھیں گے تو اس کو کلاس اے کے ساتھ ملا کے پڑھیں گے کہ جب ہم پریمیسز کو کہتے ہیں کہ پریمیسز مینز اے بلڈنگ تو اس بلڈنگ میں وہ بلڈنگ شامل ہے جو کلاس اے میں ہے. اب کلاس اے نے بلڈنگ کو 2 حصوں میں بانٹا ہوا ہے، لہٰذا پہلا حصہ مراد ہوگا. اس میں جو پراپرٹیز اس بلڈنگ کی ڈیفینیشن سے نکال دی گئی ہیں وہ پریمیسز میں شامل نہیں ہوگی. اور اس کے ساتھ انہوں نے کہہ دیا کہ ایگریکلچر لینڈ وہ بھی پریمیسز بلڈنگ نہیں ہے، اور سبسروینٹ ٹو ایگریکلچر جو چیزیں ہیں وہ بھی نہیں ہیں. اب ان دونوں کو ملا کے پڑھنے کے بعد ہمیں نتیجہ یہ نکلتا ہے کہ یہ قانون پنجاب رینٹڈ پریمیسز ایکٹ 2009 یہ بلڈنگ پر استعمال ہوتا ہے اور پریمیسز پر استعمال ہوتا ہے. اس پریمیسز پر جو بلڈنگ کی ڈیفینیشن میں آ رہا ہے اور ایکسکلوڈ نہیں ہو رہا. اس کا مقصد یہ ہوا کہ یہ قانون ہوٹل پر استعمال نہیں ہوگا، ہاسٹل پر استعمال نہیں ہوگا، بورڈنگ ہاؤس پر استعمال نہیں ہوگا، گیسٹ ہاؤس پر استعمال نہیں ہوگا، اور کسی پلیس آف ورشپ پر استعمال نہیں ہوگا. اس کے ساتھ ساتھ ایگریکلچر لینڈ پر استعمال نہیں ہوگا، اور ان تمام پراپرٹی جو سبسروینٹ ٹو ایگریکلچر ہیں ان پر استعمال نہیں ہوگا. لہذا اس ایکٹ کو ہم نے جب برسر عمل لانا ہے تو سب سے پہلے اس بات کا خیال رکھنا ہے کہ کیا جو ٹینٹ جس کو آپ الیج کر رہے ہیں کہ ٹینٹ ہے وہ ان بلڈنگز کا ٹینٹ تو نہیں ہے جو اس میں ایکسکلوڈ کر دی گئی ہیں. اگر وہ ایکسکلوڈڈ بلڈنگز کا ٹینٹ ہے تو یہ ایکٹ اپلائی نہیں کرے گا. اگر انکلوڈڈ کا ٹینٹ ہے تو پھر وہ اپلائی کرے گا. اب سوال یہ پیدا ہوتا ہے کہ ٹینٹ سے یہاں کیا مراد ہے؟ ایگریکلچر کا ٹینٹ تو مراد نہیں ہے، زرعی اراضی پر جو آپ نے ٹینٹ رکھا ہوا وہ اس میں مراد نہیں ہے. پنجاب ٹیننسی ایکٹ جن ٹینٹس کو گورن کرتا ہے وہ بھی اس میں شامل نہیں ہو گئے. ٹرانسفر آف پراپرٹی ایکٹ میں جو لیسی کی ڈیفینیشنز ہیں وہ بھی اس میں اپلائی نہیں کرتے، چونکہ اس ایکٹ میں بذات خود یہ دے دیا گیا ہے کہ یہ اٹ شیل اوور رائڈ آل ادر لاس. اس میں ایک سیکشن 4 انہوں نے بنایا، دی پروویژن آف دس ایکٹ shall have effect notwithstanding anything contained in any other law for the time being force. لہذا اس ایکٹ کا اوور رائڈنگ ایفیکٹ ہے کہ یہ اور قوانین اگر موجود ہیں تو وہ اس قانون کی روشنی میں وہ غیر مؤثر سمجھے جائیں گے. اس قانون کو لاگو کیا جائے گا، اور اس قانون میں بلڈنگ اور پریمیسز کو الگ الگ ڈیفائن کر کے ایگریکلچر لینڈ کو نکال دیا، سبسروینٹ ٹو ایگریکلچر کو نکال دیا، اور ہوٹل کو نکال دیا، ہاسٹل کو نکال دیا، بورڈنگ ہاؤس کو نکال دیا، اور گیسٹ ہاؤس کو نکال دیا، اور ریلیجیس ورشپ پلیسز کو نکال دیا. ان میں یہ رینٹ لا اپلائی نہیں کرے گا، باقی سب کو کرے گا. اب اگلا کوشچن یہ آ جاتا ہے کہ یہ ٹیننسی کا ریلیشن شپ بنتا کیسے ہے؟ چونکہ اس قانون کو اپلائی کرنے کے لیے دیر مسٹ ایگزسٹ the relationship of landlord and tenant between the parties. If they have the relationship of landlord and tenant, this act shall regulate their rights and liabilities. But if this act is, there does not exist any relationship of landlord and tenant, تو پھر یہ ایکٹ اپلائی نہیں کرے گا. لہٰذا اس کی اپلیکیشن کے ذریعے ضروری ہے کہ وہ آدمی جس کو آپ ایجیکٹ کرنا چاہ رہے ہیں، جس کو آپ ایوکٹ کرنا چاہ رہے ہیں، جس سے آپ قبضہ لینا چاہ رہے ہیں، اس کو ٹینٹ ہونا چاہیے. اب ٹینٹ کی ڈیفینیشن اس نے کر دی ہے کتاب میں خود ہی ایل کلاس میں. ٹینٹ مینز اے پرسن who undertakes or is bound to pay rent as consideration for the occupation of a premises by him or by any other person on his behalf, and includes a person who continues to be in occupation of the premises after the termination of his tenancy for the purpose of a proceeding under this act. مزید یہ کہتا ہے کہ legal heirs of a tenant, in the event of death of the tenant, who continue to be in occupation of the premises, and a subtenant who is in possession of the premises or part thereof with the written consent of the landlord, وہ بھی tenant ہوگا. अब यहाँ एक इम्पॉर्टेंट क्वेश्चन अराइज होता है कि टेनेंट कैसे बनता है. The law permits two types of agreements of tenancy. One is the contractual tenancy and the other is statutory tenancy. I put forth an example for the statutory tenancy that suppose there is a premises owned by the state. The example will be more elaborated in this context if I quote that at the time when the Pakistan came into being, there were several non-Muslims who migrated from Pakistan to India. They left their own properties in Pakistan. Those properties are known as evacuee properties. Those properties are known as evacuee properties. So there were some migrants who came from India. Those persons occupied those buildings. So they became the occupants of those buildings. The occupants of those buildings remained in possession without any title. So in 1958, West Pakistan Compensation and Rehabilitation Act 1958 came into force. That act says that the person in occupation of the property shall be the tenant of the transferee, meaning thereby that if this state property, which is an evacuee property, is transferred to any claimant or non-claimant by the state and he becomes the transferee, he gets the permanent transfer deed or he gets the provisional transfer order, he will become the landlord of the person who is in occupation of the property without any existing agreement. There does not exist any agreement between the tenant and the landlord, but in spite of this, the occupant becomes the tenant of the transferee by operation of law. So the person who is an occupant of the property when becomes a tenant by operation of law, as I stated you, then the relationship of landlord and tenant is created and he is known as a statutory tenant. And the second is the contractual tenancy. The second person who enters into an agreement under a contract is a tenant. Section 5 of this act prescribes the way of creation of tenancy. A landlord shall not let out a premises to a tenant except by a tenancy agreement. That shall be a tenancy agreement. So that shall be a contractual tenancy. The person who occupies the property of a landlord as a tenant under an agreement is called a contractual tenancy, and this tenancy is created by an agreement. So the law prescribes a mode to enter into an agreement to create the tenancy, and the creation of tenancy is accepted under Section 5. Section 5 says a landlord shall not let out a premises to a tenant except by a tenancy agreement. A landlord shall present the tenancy agreement before the rent registrar. इसके मानी ये है कि पहले किराएदार और मालिक एक मुआहदा करेंगे, फिर उस मुआहदे को लिख लेंगे. उसे लिखने के बाद लैंडलॉर्ड उस मुआहदे को बिफोर रेंट रजिस्ट्रार पेश करेगा. रेंट रजिस्ट्रार क्या करेगा? द रेंट रजिस्ट्रार शैल एंटर द पर्टिकुलर्स ऑफ द टेनेंसी इन ए रजिस्टर. वो उस एग्रीमेंट में जो कुछ लिखा होगा उसके तमाम तफसीलात और उसके तमाम क़वायद एक रजिस्टर में दर्ज कर लेगा. और फिर क्या करेगा? उसके बाद उसने ये करना है, affix his official seal on the tenancy agreement. उस पर अपनी मोहर लगाएगा, उसकी एक नकल अपने पास रखेगा और उसका असल टेनेंसी एग्रीमेंट का लैंडलॉर्ड के हवाले कर देगा। इसका मकसद ये हुआ कि टेनेंसी कॉन्ट्रैक्ट को क्रिएट करने के लिए एग्रीमेंट इन राइटिंग होना ज़रूरी है और इसका रजिस्टर्ड होना ज़रूरी है बिफोर दी रेंट रजिस्ट्रार। उसके बाद the entry of particular tenancy shall not absolve the landlord or the tenant to their inability to register the tenancy agreement under the law relating to registration of the documents। इस रजिस्ट्रेशन का मकसद ये नहीं है कि ऑर्डिनरी लॉ ऑफ रजिस्ट्रेशन एक्ट ख़त्म हो गया, वो अपनी जगह पे कायम रहेगा। अगर वो डॉक्यूमेंट रिक्वायर्ड बाय द लॉ टू बी रजिस्टर्ड है तो उसको रजिस्ट्रेशन एक्ट के तहत रजिस्टर कराना होगा। Subsection 6 है, any agreement which may be executed between the landlord and the tenant in respect of the premises shall be presented before the rent registrar in the same manner as provided in subsection 2. It means that the agreement should be produced before the landlord, by the landlord before the rent registrar, and the rent registrar shall affix his seal thereon, and then it shall be registered, and on the registration of this document, the tenancy shall be created. So this tenancy agreement is a contractual agreement. So there are two kinds of the contract of the tenancy. Number one is the statutory tenancy, which comes into operation by the operation of law, and the second is the tenancy which comes into existence on the agreement which has been executed under section 5 of this act.
Well, gentlemen, we were discussing the creation of tenancy, and we saw that there are two types of tenancies. One is statutory tenancy and other is contractual tenancy. The Act states how the tenancy is created. Under section 5 of the Act, a landlord shall not let out a premises to a tenant except by a tenancy agreement. So there should be a tenancy agreement in order to constitute a contractual tenancy. Section 5 explains how this is created. Under section 5 subsection 2, a landlord is under an obligation to present the tenancy agreement before the rent registrar, and the rent registrar shall enter the same in the register and get it registered in accordance with the provisions given under the Act. So the tenancy is created through an agreement as prescribed under section 5 of the Act. So section 6 of the Act explains the contents of the agreement. What should be in the document? The document should be explicitly revealing that it has the particulars of the parties, it has description of the premises, it has got the period of the tenancy, it has the rate of rent, and it has the other particulars as prescribed in this section. On going through the section, we find that there are certain descriptions which are necessarily to be given in the agreement. So the existing tenancies shall remain in force, but the time has been given for this purpose of 2 years that these tenancies may be got registered in accordance with this Act as prescribed in section 5 of the Act. So there are certain obligations of the landlord and there are certain obligations of the tenant. If a dispute arises between the landlord and the tenant, then the law will come for the rescue of the parties. This act describes the grounds for eviction of the tenant. The grounds of eviction of the tenant are given in this act. Those are grounds for eviction under section 15. A landlord may seek eviction of the tenant if the period of tenancy has expired. Number 1. Number 2, the tenant has failed to pay or tender the rent within a period of 30 days after the expiry of the period stipulated in section 7. So these are the two most important grounds which are generally available and which are the basis of seeking the eviction of the tenant. There are certain other grounds. Number C, the tenant has committed a breach of a term of condition of the tenancy agreement. The tenant has committed a violation of the obligation. The tenant has used the premises for the purpose which is different from that which was for that purpose which was given to him, and the tenant has sublet the premises without the prior permission of the landlord. So these are also the grounds. But the main grounds which are usually we come across are that the period of tenancy has expired and the tenant has failed to pay the rent as stipulated in the agreement. So the default is the ground. So for the purpose of determining these disputes, this act establishes the rent tribunals and provides the procedure thereof. When a tenant is committing the breach of any term of the contract and the landlord had the ground as prescribed in section 15 of the act, he may seek the eviction of the tenant on any of the grounds given in the act. So usually it happens that a tenant denies the relationship of landlord and tenant. Where the relationship does not exist, the rent tribunal shall have got no jurisdiction. So his jurisdiction starts from this point, that he is to determine whether there exists relationship of landlord and tenant between the parties. So when a tenant denies the relationship, the first question which is to be answered is put to an issue, and an issue is settled whether there exists a relationship of landlord and tenant between the parties. It is treated as a preliminary issue. It is a preliminary issue because the fate of the petition is dependent on the issue. The question of jurisdiction is involved in this issue. So when the court has to take the jurisdiction, it has to decide the question of jurisdiction first. So this question is first decided, and it can only be decided when there exists the relationship of landlord and tenant between the parties. So when the rent tribunal comes to the conclusion and maintains that there exists the relationship of landlord and tenant, there does not remain any ground for further proceedings, because the man who is denying the relationship is also admitting that he never paid the rent. So he is a defaulter. The law says that when it is proved that he is a tenant and his denial is evasive or his denial is refused by the law, and if it is maintained by the court that there exists the relationship of landlord and tenant between the parties, the court shall extinguish his tenancy, and on the extinction of the tenancy they shall be ejected forthwith. So whenever there is a defense of denial of relationship, this question is taken as a preliminary question and then decided by the court. But if the court comes to the conclusion that there does not exist the relationship between the landlord and the tenant, then the rent tribunal shall have got no jurisdiction to proceed further. The petition shall be dismissed. If there does not exist the relationship, the petition is dismissed and if there exists the relationship, then it is accepted without further proceedings. So the tenant has only two defense. One is denial of the relationship, and other is denial of the averments in the petition. Whatsoever is stated by the petitioner are denied by the tenant. And third is the admission by him. If he admits, he shall be rejected. But if he denies, those questions shall be put at an issue. The court shall settle the issues, and in this case situation, the tenant shall be entitled to cross-examine the witnesses whose affidavit have been already filed in the court. So the difference between this act and the West Pakistan Urban Restriction Order in 1959 is that this act does not allow a tenant to contest his suit without leave of the court. The tenant is first required to seek the relief in the sense that he will ask the court to allow him to defend the proceedings. But if he is not allowed, then he shall be forthwith rejected. But if he is allowed, then in this situation, he shall be allowed to cross-examine the witnesses and then shall read his own evidence. This provision has been incorporated in this act for this purpose, that in the previous ordinance the tenant had so many defenses available to him, and he tried 1, 2nd, 3rd, 4th and 5th, and in this way his unscrupulous defenses were an agony for the landlord. The landlord could not bear the brunt of the protracted litigation, and the tenant engaged him and entangled him in the long litigation. So the law said, first tell us the defense. If you have a good defense, then the law will allow him to contest the petition. If he has got no good defense, then he shall not be allowed. So in this way, this act is meant for the speedy disposal of justice, to avoid such litigation which is in fact frivolous, and the tenant cannot be allowed to play hide and seek with the landlord and enjoy the occupation of the property, and the landlord remains out of the possession. After leave is granted, he shall contest the suit. He shall contest it and will give his defense and prove it. So, after the conclusion of the trial, the court shall either dismiss the petition or the court shall order the eviction of the tenant. Another important thing which has been given in this act is that the court has ample powers to pass an order of arrears of rent. The arrears of rent may also be recovered from the tenant in these proceedings, and the court may make an order during the pendency of the proceedings to direct the tenant to deposit the rent monthly or as agreed in the tenancy agreement. So the tenant cannot enjoy the tenancy without payment. He must pay the rent during the pendency of the suit, and he must pay the arrears as required by the court. So when the order is passed, then it should be a final order. And if there is a final order of ejectment, then the right of appeal is given under this act. Section 28, I am going to read it. a person agreed by a final order. What is final order? It is very important. The final order is an order which conclusively determines a fact. If the landlord alleges that the tenant has committed default and this question has been conclusively determined by the court and the court has passed the order of eviction, that is final order. In this way, on any other ground, if the court passes a final order and disposes of the petition, then a person agreed by that final order may within 30 days prefer an appeal in writing to the district judge of the district. So, for the purpose of filing an appeal, there should be a final order. There can be no appeal when there is no final order. The same point has been given in subsection 2. No appeal shall lie against an interlocutory order passed by a rent tribunal. Interlocutory orders, interim orders, all orders other than the final order shall not be appealable. So, when a person agreed by a final order may prefer an appeal, and the period of limitation for the filing of the appeal is 30 days, prescribed by this Act. So, the period of limitation is not governed by the Limitation Act. The period of limitation is governed by this Act, and when a special act prescribes the period of limitation, then the Limitation Act will not come into play. Number 3, if an appeal under this section is preferred, the district judge may hear and dispose of the same or entrust it for disposal of an additional district judge of the district or the area area. This is an explanatory clause. It gives powers to the district judge to hear an appeal, or he may entrust the appeal to any additional district judge. So, the additional district judge is also an appellate forum, but that forum exercises its jurisdiction only if the appeal is entrusted to him. It means he cannot directly receive the appeal. The appeal is always filed before the district judge. He may himself hear it, or he may entrust it to the additional district judge. So, in the strict sense, directly an appeal to the additional district judge shall not lie. It shall lie to the district judge, and it is discretion of the district judge either to hear himself or entrust it to any other person, additional district judge. The district judge or additional district judge may, after providing an opportunity of hearing to the appellant, dismiss the appeal without notice to the respondent. It means that after hearing preliminarily, the court may dismiss it if the court finds that the grounds are not cogent, the grounds are not substantial, the court feels that there is no need to probe into the matter further, that there is no misappreciation of evidence, there is no question to be determined by the court and the London lower court had rightly decided the case, then in this situation, without giving notice to the other party, the court may dismiss the same. The next is number 5. The district judge or the additional district judge may, where the circumstances so require, suspend the operation of the final order. The operation of the final order is suspended to avoid the execution of the order during the pendency of appeal. If there is an appeal pending and that is admitted for hearing and the court has got no jurisdiction to suspend the same, the result would be that the other party shall go to the executing court and get it executed and will get the possession without decision of the appeal. So this power has been given to the appellate forum, that the appellate forum may suspend the final order till the disposal of the appeal or till such time as the court thinks fit. Number 6, the district judge or the additional district judge may exercise any or all of the powers of a rent tribunal under this act. It is a basic principle of law that is known as doctrine of merger. The judgment of the lower court merges into the appellate forum. So the appellate forum has all those powers which are available to the trial court. So this has been enunciated in it, that the district judge or the additional district judge may exercise any or all of the powers of a rent tribunal under this act. So the appellate forum exercises the powers of the appellate forum as well as the powers of the rent tribunal. Number 7 is the district judge or additional district judge shall decide an appeal within a period of 2 months from the date of the filing of the appeal. The period has been prescribed and direction has been given not only to the court but to the parties as well, that it is to be decided in 2 months. But if it is not decided, then what? The court shall not lose the jurisdiction. We cannot say that 2 months have expired, so the court has got no jurisdiction. The court shall have the jurisdiction till it is finally decided. But this period has been given in order to find out the speedy disposal of justice, so that it is a directory one and not a mandatory one. It gives the direction that it should be decided within 2 months. So number 8, no appeal shall lie against an order passed by the district judge or additional district judge under this act. It bars the second appeal. So the order passed by the district judge in appeal shall be final and no appeal shall lie therefrom. So the second appeal is not provided. This act does not provide the revision, so the no revision shall lie. It does not provide the review, so no review shall lie. When the district judge or the additional district judge makes a judgment or order in the appeal, this appeal shall be final. There is no revision, there is no review of that appeal. Once the order is made by the appellate court, the order of the lower court merges into the order, and if it is an order of eviction of the tenant, then the original court shall have the jurisdiction to execute it, and it shall be executed as if he is a civil court. So the section relevant for this purpose, I am going to section 31. The rent tribunal shall execute an order passed under this act by a rent tribunal or a district judge or an additional district judge as a decree of a civil court, and for this purpose the rent tribunal may exercise any or all the powers of a civil court. So when he is proceeding with the petition, when he is proceeding with the eviction petition, he is not a civil court. So in that situation, CPC shall not apply. But when he acquires the jurisdiction to execute the order, final order, he shall exercise those powers as a civil court, and all those powers which are available to an executing civil court shall be available to the rent tribunal. So he may execute his own orders as if he is a civil court. Yes, so far as the question of writ is concerned, it has an independent scope. If the case falls within the constitutional provisions and the Constitution permits the ground, then the writ is competent. The writ is not competent under this act, but that is competent under the Constitution. That will be a constitutional writ. So far as the appeal, review and revision are concerned, those are prescribed according to this act. This act provides first appeal against the final order and no other appeal. It does not provide revision, it does not provide review. Thank you.